Good afternoon, good morning. Thank you for joining us for this CIPL first webinar in this new year that is going to discuss a really important topic, and that is how does data protection, regulation, oversight, compliance look like in the age of generative AI. And in particular, we've brought a group of some leading regulators and also leading practitioners to give you both regulatory and practitioners' perspective. First of all, very briefly, let me introduce CIPL. For those of you who do not know us, this is a public event. We decided to open it beyond just CIPL members and friends and family because it is an important topic. CIPL is global privacy data policy think and do tank operating out of London, Washington, and Brussels. We have been working on the intersection of law, technology, compliance, and public policy for over 20 years. And our mission is threefold. One, how do we enable responsible use of data and responsible development of technologies in this new fourth industrial revolution? So how does privacy and responsible use of data sit together with innovation? Secondly, how do we build bridges between regulators and regulated entities and work together in a constructive engagement? And thirdly, how do we build convergence and more understanding and interoperability globally so that just like people, technology, business processes, our rules, laws, interpretation is also as much aligned? We have been convening these kind of conversations for a very long time, and I'm really delighted that we are speaking about this topic because it is hugely important. First of all, transformative power of AI has become apparent to everybody from private to public sector to government. It's shaping everybody's economic business strategy, economic societal progress and strategy as well. Of course, at the center of AI is data, and data is driving this new revolution, frankly, that we are seeing in the fourth industrial revolution with the adoption of AI. And that data is both personal and non-personal data as well. Secondly, of course, the question of how does data protection sit with AI is not new. I mean, we have got laws that regulate use of personal data in AI as well. For some time, GDPR in Europe and various privacy laws around the world. And we at CIPL have been working and writing about this already. So we're not working in a vacuum. We do have legislative regulatory regimes. And so the question is, how does that regime work with the new technologies? How do privacy principles potentially evolve in their interpretation and implementation, both by regulators and in companies as well? Do we need to reconsider how we interpret these principles in light of the technologies? Because we also identified some tensions, and we'll talk about that as well. And it's really good to see regulators grappling with these tensions and also creating legal certainty as well in the industry, in the marketplace. We also do believe that privacy is important, pro-innovative element of AI. We need to make sure that AI is trustworthy, can be used for the benefit of the society and economic progress as well, and that privacy element is going to enable that. But so how do we do that? How do we ensure proper implementation of principles? How do we ensure that privacy rules are that AI enabler as well? And what is the role of regulators in all of that? That's really the question for today. So very briefly, before we start with the conversation, if I can just show you, we have been working on the intersection and on the topic of AI at CIPL for very many years. You've got a number of QR codes where some of our key papers from 2018, where we identified first time some of the tensions in the application of privacy principles and how technology work. And then in 2020, where we talked about the application of GDPR to AI. And then we looked into, of course, legislative developments from the EU AI Act to Singapore, to US, Brazil, Canada, and other countries. In the last year in particular, we focused on two projects. One was on how do we create the best regulatory regime for AI, how to regulate AI, and our paper is there in the QR code. And we also conducted an empirical evidence-based research project where we, with 17 leading companies, we actually collected all the best practices in accountable AI. And we kind of put them against CIPL's accountability wheel and framework to show what were those emerging practices. And we will continue to do that because we do believe there is a lot happening in the market, irrespective of any legal developments. There's a lot of accountable AI development and deployment taking place. So we do want to socialize these best practices and make sure they're widely spread and used. In other words, what does good look like, and how do we make sure that everybody can take the benefits of what good looks like? And very briefly, the focus for the really last end of 24 and the next 25, Malaka, if you can just put next slide, please, is going to be for us in two areas. First of all, it is exactly this topic of today, which is how do we evolve, reinterpret data protection principles to sit and to be fit for the purpose of AI technology, including Gen AI, but frankly, also agentic AI and the next evolution of AI technologies. We published this paper in early December. You have got the information there. And this is really the paper that I hope has also influenced some of regulatory developments as well. We will continue to work on this because, as you will see, lots of questions remain unanswered. Lots of best practices still need to be considered, and we will talk about them today. Now, our second focus is going to be particularly on the implementation of the EU AI Act, an important legislative piece, first of its kind, and we want to make sure that we, again, create those best practices, exchange the views, work with regulators to understand the meaning and the obligations and requirements of the EU AI Act, and of course work on what does a good program of accountable AI program look like under the EU AI Act. We are working with a number of business leaders and technologists and privacy leaders because, of course, very often responsibility for AI at the moment still is sitting with privacy teams, if not also with responsible AI officers. So this project is important because its aim is to really inform the market as to what good looks like and create that legal certainty, but also inform the rest of the world in terms of legislative choices that they are all making around the world as they're considering how to regulate AI. So with that, I would like to open now our discussion for today. And first of all, welcome very much our speakers for today. As you can see, we are going to run this in two parts. One, the conversation with regulators. Second, the conversation with some of the business leaders, practitioners, and then we're going to open for Q&A. But of course, feel free to put things in your chat. I'll be trying to look at the questions as we go along, and I'll try to include them in our conversation. But if they're not answered, we'll have a short time at the end with everybody together to perhaps touch upon some points. So let me just introduce our regulatory panel first. Delighted to have Diletta De Cicco, who is a legal officer, litigation international affairs at EDPB, and has been one of the main authors and contributors to the new EDPB opinion on Gen AI and data protection. Secondly, Stephen Almond, who is Executive Director at Regulatory Risk at the UK Information Commissioner's Office, and Félicien Vallet, who is the Head of AI Department at the French CNIL Data Protection Authority. So again, three leading the authorities, all three of them have in the past year been working on how data protection rules apply to AI. And we've seen some really helpful and thoughtful guidance, starting with the CNILs, how to cheat sheets, as we call them, consultation done by the ICOs, and of course, cherry on the cake, which was the EDPB's paper opinion, in fact, on the application of principles to AI. So first of all, I'm going to ask all three of them to just reflect a little bit on the work done by your offices in this last year and some of the highlights of your position where you've ended, and then we're going to go into Q&A. So Diletta, can I actually start with you, please, from EDPB perspective? Thank you.
Yes, of course. Good afternoon and good morning, everyone. Thanks a lot for the introduction. Bojana, I will share today my personal views, but as you mentioned, one of the things I worked on in the past months was the recently adopted opinion of the EDPB on AI models. And as you also mentioned, there is more than the EDPB is doing in the area, and I will be happy to share insight on this today. The EDPB opinion on AI models definitely marks a major milestone in the field of data protection and AI, as it set for the first time an official position of EDPB in the area of AI. I would like to highlight that the opinion is not guidelines, so this for sure introduces like a difference with the documents that will likely be discussed by the ICO and by the CNIL. So maybe before going and digging a bit into the key takeaways of the opinion, I think it would be good to provide a bit of elements from a context perspective on what the role of an opinion, because I think it's good to set the scene before we start the discussion today. Certainly, this opinion underscore what is the role of the EDPB in the area of AI, and it's, as I was saying, one of the things we have done, and is one of the elements, is one of the steps towards providing clarification on the application of data protection in the context of AI. The role of the EDPB opinion on AI models is to provide consistency. So consistency opinion under Article 64 are opinions that set a common interpretation at EU level on certain specific elements, and this is also why the opinion is so important. The weight of an opinion is actually bigger than the one of guidelines, because opinions are addressed to supervisory authorities that will have to take into account the general considerations provided by the EDPB in the context of the opinion when they will deal with specific cases. And if this is not done, there's a possibility to escalate it to an Article 65 binding decision. Something that is probably also important to remember about opinion is that, as you might know, the EDPB works under a very restrict time window when working on consistency opinion. In this case, we had 8 weeks plus 6 weeks. The 6 weeks can be added if the case is quite complex. And during this time window, the role of the EDPB was providing responses to specific questions that were asked by the Irish Supervisory Authority. These also tell us what is the scope of the opinion. The EDPB doesn't have a margin of maneuver about what the opinion will address, but the idea is really to clarify aspects identified in this case by the Irish SA. The Irish SA requested the opinion because, of course, as you were mentioning, Bojana, AI raises complex, novel issues about the application of data protection, and some of these questions are addressed in the opinion. 3 main topics, I would say, are covered by the European Data Protection Board. The first one relates to when and how an AI model can be considered anonymous. In this case, we could say that, in a nutshell, the EDPB states that an AI models can be considered anonymous when using reasonable means, both the likelihood of direct extraction of personal data as well as the likelihood of obtaining personal data through queries is insignificant, and the opinion gives a non-exhaustive list of elements that authorities can consider when they evaluate a claim of anonymity. The second main topic of the opinion relates to whether and how legitimate interest can be used as an appropriate legal basis for the development, for the processing that happens during the development and the deployment of AI models. And here the DPB goes through the legitimate interest assessment test and provides some elements that can be useful when assessing whether legitimate interest can be relied on for processing personal data in the context of development and deployment of AI. And finally, the third topic is related to the possible consequences of an unlawful training of AI models on the subsequent operation of use of a model. And here I would say that the key takeaways is that unless a model is truly anonymized, there might be an impact of the initial unlawful processing on the subsequent use of the model. And to close my, let's say, opening remarks, I would just like to say that, of course, as I mentioned, this opinion is important. It was a long awaited opinion. And as you may know, the DPB also considered important to listen to stakeholders' view and organized for the first time in the context of an opinion a stakeholder event. But of course, the DPB is aware that this is a first step towards bringing consistency in the area. We're also working on guidelines. We're using the support pool of experts to run projects in the area. We are supporting DPAs with the task force ChatGPT. So there's much more we are doing, and I will be very happy to provide more insights during today. Thank you.
Thank you, Diletta. And I think this is really important to understand the power of the opinion, as you say, and the weight it has got. Obviously, it is directed to the DPAs, the supervisory authorities, and directing them how they should be applying the law. But of course, it has got a very big impact on all of those who are either developing or deploying Gen AI. And it does actually it does address the key question, which is, one of legal basis, as well as some others, of course, and we'll talk about that. Stephen, so could you maybe tell us, I'm sort of going here a little bit backwards, right, in terms of who was the last who produced. Now, ICO was the second to last. Just before December, you published the response to the consultation, where you gave your orientation on similar questions. So again, share, please, with us.
Thank you. And I'm probably going to kind of query the numerical ordering here in terms of kind of putting out outputs, because ultimately, and this is one of the things that I'm going to be honest kind of frustrates me about our conversations around how data protection law applies to AI is not new, and many of the concepts that exist in data protection law have been applied to AI for a long period of time. So for the ICO, actually, when we came to the questions around generative AI here, we were really looking at, well, what is new here? What's novel that we need to apply law to? So we will no doubt later today talk about questions of how do you train models based on first-party data, for example. That is a practice that has been going on for a long time. There is very little that is novel in this space around that. But we did find new things, new questions where people did have genuine concerns about regulatory uncertainty, and we wanted to provide that clarity. So as you've already set out, we ran a consultation series last year based on our market study that we'd run the previous year looking at practices within firms. And we identified 5 particular areas where we thought it was really important to provide regulatory clarity. One, we've already touched on, that question of the lawful basis for web scraping. And how that is looked at in practice. To the question of how does purpose limitation apply when you're talking about models which are thought of, at least in some, some circles, as being general purpose, and how do those concepts align in that space? How does, for our third area, the question of accuracy apply in the context of models which may or may not be being used for the purposes of generating accurate outputs, or actually for ideation and creation in this area? And what's the distinction between how data protection law might apply in that sort of context? Fourth, looking at the question of people's individual rights and looking at how they are being engineered into models right now and how those practices are evolving in future, particularly in the context of models where actually it's not necessarily so straightforward to be able to take data out, as it were, and retrain a model. Looking at the practices that exist there, such as input and output filters, the extent to which they really address data protection concerns that might exist. And then finally, we thought we'd leave the easiest question till last, namely, who's accountable? There are complex supply chains here of different processing activities that are playing out differently for different parties across the market. It's really important, if we are going to get kind of true protection of people here, that everybody knows what part of the data protection puzzle they are responsible for solving. And so we set out draft views on that. We consulted across the year, and I'm really happy that towards the end of the year, we published our response to that consultation. It's a high-level response that sets out firm policy views from the ICO, but it's not, at this stage, guidance. It is not yet quite so detailed and prescriptive. That bit will follow. We're conscious that in some cases, in some small areas of this, there are still spaces where we would like to have more conversation. Questions of actual methodologies, for example, for determining when a model is anonymous, does not contain personal data. Questions around when certain mitigation measures are deemed effective. We know people want more clarity on those. We know that there's technical development in this space. We're really keen to sustain that conversation as we crystallize towards a final set of more detailed rules that tell you what you must do, what you should do, what you could do in this area. So that will follow. But there's an awful lot of detail. And I must thank everybody on this call who contributed to our consultation process. It was a very open and rich process that generated a lot of insights. I must also say thank you very much to our partner data protection authorities, who also fed in their views and worked with us, and a special shout out to our friends at the CNIL, who really did help us so much in sharing their thinking as we forged our views here. There's still some way to go around this, but this, I think, really does mark a pivot point for us as a regulator, where we start to move away from looking at how the law should be interpreted in this area and more to how the law should be adhered to in this area. We did, on publication of our response, highlight some areas of concern as well. The particular one that I want to highlight, that I'll come back to no doubt, is a concern about particularly where web scraping is being used for training of models, the extent of transparency that exists for people about how their data is being used. And to be frank, we have not found that done well enough. And so, please, for those of you who are on this call who are thinking about, well, what is the sort of thing that Stephen and his colleagues may turn to look at very soon, please take note of that. But I'll park there.
Sorry, I was on mute. Thank you for that. First of all, it's great to see that the collaboration and the conversations continue among the data protection authorities, even though UK is not part of the EDPB and has Brexited, but I think it's absolutely right to see that cross-pollination of points of view. And on the point of sort of what does good compliance and best practice look like, I mean, we will touch upon that today, but indeed, I think we're hearing the message, okay, here is the interpretation, but now let's see how the compliance comes back and what organizations have to do. We will address that, and transparency is one of the questions I will be asking. I do want to actually give a shout out to the work that you and the team have done a few years ago when through the series of blogs and some very open consultations, you kind of really address the whole topic of data protection and AI and trade-offs and how the principles and different considerations work together. I think that was very helpful very early on in forming some of the best practices that CIPL has seen, particularly around documenting those trade-offs. But we'll explore more. Félicien, what about CNIL's work?
Yes, well, thank you very much, Bojana. And first, well, I'm very glad to be here and share CNIL's thoughts with the colleagues and the audience here. So I return to what said Stephen just before, as being the topic is on one hand new and at the same time not so much, since we've seen as in every DPA that more and more uses of AI technologies over the last, I'd say, 10 years in various sectors, such as security with smart cameras, or retail, or healthcare, so on and so forth. But with the steep increase occasioned by the arrival of Gen AI technologies, the CNIL decided to create this department that I'm honored to lead, and we decided also to start to engage a plan, to engage actions, to bring some legal certainty, legal security for actors, and bringing them some practical recommendations on how to do things. So those were the practical how-to sheets you were mentioning just before, and they proved to be so far somehow a success, even though heavily discussed, obviously, and not necessarily everybody agrees on everything. And still, the second batch of the how-to sheets has not been yet completely adopted. And this is a current work we are doing, in particular because we've been heavily involved in the EDPB opinion mentioned earlier, and since we want to take it into account to be perfectly aligned with this consistency mechanism that Diletta presented earlier. So that's basically the work we're engaging at the very moment. I don't want to be too long, but if I were to share what stands out for me regarding this topic we are discussing, one thing is that the topic is the ecosystem is very complicated and very scattered, and that's part of the biggest issue to me, is that you have to deal with so many actors that do so many things differently along the value chain, and that do not necessarily speak to each other or have any link of any kind. So you have those that actually collect data to build data sets, those who are training models, those who are actually hosting models on platform or data sets, those who are actually using these models to fine-tune another one, maybe to import it and integrate it in a product, and some who are in the end deploying it. So basically, you have data processing at each step of this chain I described, and you have questions, and you have also the question of the traceability and the fact that maybe in the end, you, as the last person in the chain, you will have to be able to come back to know how the processing was done in the first place, and it's not necessarily easy. We know all that all too well. So I think those and then it turns out it's the very practical question Stephen raised earlier on how to exert right, how to inform correctly a person. But I think it's the specificity of the AI ecosystem that also brings a complexity. Also, another specificity is that you have some weird objects, and these, in particular, these AI models we've been discussing before. I suppose 10 years ago, no one was actually wondering whether these AI models could be thought of we thought that data protection laws could apply to them, and now it is actually the very hot discussion and the and the subject of the opinion that Diletta quickly presented and will explain further later. So I think those are the specificities. And the third one, so complex chain of value, new objects. And the third one is also the interregulation that we observe, being that, well, we are talking about data protection right now, but actually if you do not take into account other regulations, and for instance, in Europe, the European AI Act, then you miss something. And for instance, when we are talking about transparency requirements, it's complicated, even if it's not on the same level, to completely ignore what is required by the EU AI Act, and for instance, the current works led by the AI Office regarding the code of practice for generative purpose AI models. So all these, I mean, is kind of the specificity of this very topic of Gen AI and its regulation by data protection regulators.
Excellent, and thank you for raising the point about the interregulation. I think this is something that we have identified for some time, not just in respect of AI Act and GDPR, but of course each of the digital regulation or data regulation, from competition, DMA to safety. But I think to the point of transparency, it's not just transparency. I mean, the AI Act talks about fairness, right? It talks about, again, accuracy, security. So what do these obligations look like under the EU AI Act? And what do they look like with GDPR? And how do we make sure the two don't conflict, but at least compliance towards one can be also used as compliance towards the others, but they're not the same. And I think that's, we can talk more about that. We will, and I think maybe this is something for CIPL also and our members to think a little bit about. And the point about the complex ecosystem, I think we're hearing you very well, and I believe Stephen has identified that, and the EDPB opinion identifies that it really is different. Compliance looks very different for different actors in the system, and they do not correspond to controllers processors at all in the data protection lingo. Let me sort of ask you a more substantive question, which is one of really legal basis for processing, but the distinction between first-party and third-party data. I mean, yes, first-party data use isn't new. Every organization is trying to use existing data for purposes of training or product development or even pure R&D. And so what I think Stephen was kind of new is that the noises around Gen AI brought into focus the use of first-party data, and some organizations were not sure whether they can use or continue to use their own data for AI LLM development, where there is a real benefit to do so. And then, of course, third-party data is this web scraping use of data from third-party sources. So do you three want to comment on the approach that your agency or your authority has taken to these two scenarios? And does the legal analysis look different if it is first-party data or third-party data? Somehow we seem to think third-party data is more risky because it's coming from, but anyway, I'm not going to put words in your mouth, please. Who would like to kick us off here?
I don't mind starting the debate
Yes,
around it. Ultimately, to state the blindingly obvious here, with first-party data, the organization has a relationship with the data subjects. And that does add a different dimension to it. Now, as I said earlier, this is not something that we have covered off in our own consultation series, because as far as we're concerned, this is a settled question around the use of first-party data here. But fundamentally, it's a question of, well, how do you balance out, if you are for first-party data, using legitimate interests as your lawful basis, how do you go about undertaking the balancing test? And it's not for me to say that automatically you are more likely to be compliant if you use first-party data over third-party data. It's actually, it will all come down to how that balancing test is undertaken. But of course, having direct access to data subjects in order to, for example, facilitate the carrying out of their rights, provides, puts you potentially in a stronger position, so long as you make use of that relationship that you have with the data subjects, to demonstrate appropriate transparency, to demonstrate greater opportunities for data subjects to exercise their rights to object to processing, for example, which of course become harder the further away the data subject is from the entity that is undertaking the processing, and the less aware that they are. So yes, of course, going back to my earlier points around transparency, yes, if you are scraping data from the public web, for example, you're purchasing third-party data here for the use of model training, then of course there is going to be an additional hill to climb here, which is going to be, actually, how are you going to demonstrate that actually the balancing test will stack up, that you have provided appropriate transparency, that people can undertake things like their right to object or their rights to rectification in this area. And of course, that's going to require some additional thinking in some cases for organisation. It's thinking that, quite frankly, we have not seen some organisations undertake enough of. Of course, it's perfectly possible, and very sadly so, for you to be an organisation using first-party data and for you to still not make use of that communications channel that you have with the data subjects in order to facilitate those rights. And of course, we would also look on rather dimly.
Diletta?
Thanks, Bojana. I think based on the opinion, there are two main things I would like to share, and that also build on what Stephen was saying, because transparency and the relationship you have with the data subject certainly play a role in the legitimate interest assessment. And these are the two topics that are more related to the difference between first-party and third-party data that controllers need to take into account when running the test. So the first one is a general consideration, as I think is important to highlight that the opinion clearly states that there is no hierarchy between the legal basis. So legitimate interest can be considered as a possible legal basis for both first-party and third-party data, depending on the assessment that is conducted and based on the factual circumstances of the case. And this, of course, will have to be considered based on the specific scenarios. But also, I think what comes out of the opinion is that, of course, the difference between first-party and third-party data needs to be considered and play a role. But there are some elements that are important and have equal importance, that are presented in the opinion together with the type of relationship that the controller has with the data subject. So on top of whether data are first party or third party, there are elements that are mentioned in the context of the balancing test. So for instance, when you look at the reasonable expectations of the data subject, and these elements are personal data publicly available? Who made the personal data publicly available? What is the source? Where data were published? What type of website it was? What type of protection there was on the website? What is the nature of the service? So first party, third party, I think is one piece of the elements that needs to be considered, but is not the main one for the European data protection board. Of course, then this difference translates on top of the way you have to inform data subject, because of course when it's third-party data, things might get a bit more complicated than when controllers have a direct relationship with the data subject, but it also translates in the type of mitigating measures controllers can put in place. If you look at the opinion, there are some mitigating measures that the EDPB identifies specifically for web scraping, and some others that obviously will be easier to put in place for first-party data. So yeah, for sure, as I was mentioning before, there is more clarification to be provided. I think it's interesting to mention that the EDPB is also working on guidelines on web scraping that will touch upon likely some of these elements, but hopefully already the initial considerations of the EDPB will be helpful to have some reference on things that are important to consider both for first party and third party data when you look at legitimate interest as a legal basis.
And Félicien, the same to you.
Well, I'll be quick because Stephen and Diletta already shared most of the thing I wanted to cover. Just wanted to take a bit of distance with and just saying that this is what was presented was actually what CNIL was viewing mostly the subject, and in fact it actually helped us to have our AI how-to sheets before this opinion work actually started, so we actually knew where we what we thought on some of the topics discussed within the opinion. But it is also true that it was not necessarily shared among all our counterparts, and some discussions had to be made, and so it was very important to have this clarification and state, as Diletta said, that there's no hierarchy between the legal basis, that it is possible to rely on legitimate interest, but also that depending on the case-by-case analysis, whether it is first-party, third-party data, or other specificities, obviously, that you will have to do this balancing test and take into account a number of things to make sure that actually it is not detrimental to data subjects. So yes, but in practice, I think we are pretty much aligned with what is said just by.
Yes, I think actually what I have noticed in CNIL's how-to sheets, there was also the link to purpose limitation, because it seems to me this isn't a question of first and third-party data. Particularly first-party data isn't always just the legal basis, it's also purpose limitation, because data is collected for one purpose, but now all of a sudden this data is incredibly useful or maybe even necessary for proper building and development of the AI or training of the AI. And it's really, you know, that I think consideration and recognition that in fact there is a different purpose of the original processing, and training is a separate purpose for which then legal basis need to be found. I mean, I think it's a nice touch in CNILs, and I can see that in EDPB as well. And I kind of think that's also something that I think people and organizations would really appreciate, because it isn't just legal basis, it's also purpose limitation. And if I may also say, kind of the point about reasonable expectations of individuals, I think that comes across a lot in EDPB guidance, of course, opinion as well in the ICOs. But that's one where I think we all need to do collectively better. I mean, people reasonably don't expect anything at the moment, but as these tools are getting more and more used, as there is a better understanding of how AI it actually happens and how it is built, you know, it's a dynamic concept. So I think that's something that organizations will probably have to deal with, you know, consider that themselves as well. And I like the point that you all three made, which is the transparency is actually a point. It's a point on its own, but it is linked to legitimate interest and to first and third party data. But it doesn't really, the fact that you have got access or not to individuals doesn't determine the legal basis. It just determines how you're able to give transparency, and therefore maybe also do the balancing test. I mean, I kind of felt that those are really Now, Stephen maybe agrees, it doesn't agree. I permitted myself, at least in the EDPB and CNIL opinion, to kind of stretch that a little bit. But I take your point. You think that transparency is very much linked, but it's a separate legal concept, Stephen, as well.
It is, but I struggle to see, if you have absolutely no transparency, how you could say that you have met the balancing test. So, I think these, as with all of GDPR, these concepts are deeply intertwined, and failure to meet the expectations of one of them does have then knock-on implications for the rest.
Right. And maybe also you would fail fairness, right? If you are totally, in terms of, lack of transparency. Okay, can I actually ask about transparency? Because I did have a question there. I mean, you all, we in our paper, we also talked a lot about transparency and how important this is. And there is this element of reasonable expectation of individuals. Stephen, you said you haven't seen particularly good things, but I mean, how far do organizations need to go, both in terms of first-party data, but also third-party data? I mean, it's really difficult to, would this literacy requirement under the EU AI Act help as well explain in general about sort of the web scraping and use of third-party data, or use just generally data for AI training?
So,
what do you think is important?
So first of all, it's worth saying, actually, particularly in relation to first-party data, this is an area where we see some organizations also doing some things well, in terms of, for example, some organizations have gone as far as providing just-in-time notifications to their users, saying, actually, look, we are giving you a window to opt out before we start using doing prospective, using your prospective data, so your future posts or contributions, etc., to train our models. I mean, that's a very high standard, arguably, in terms of being able to say, look, it is extremely clear to people how their data is being used. They've been given the appropriate opportunity to object to something which actually may end up being, in some senses, irreversible processing. Now, at the other end of the spectrum, I think we find organizations who actually, not only do they not have a relationship with the data subject themselves, but they are looking at the sort of the questions around, I suppose, disproportionate effort here, and using that lack of relationship to justify not providing any transparency in any meaningful sense at all, such that a user who has got reasonable expectations that they could go to a firm and find out whether their data is likely to be being processed by that firm, for example, could actually follow through and could exercise their rights. And that's where I see it being very difficult, really, for firms to be able to say, look, people should just expect that their data has been scraped and expect that we might be processing some of it, and kind of they should work out for themselves how to get in touch with us. I think that is a rather poor approach to transparency. It's an area where I'd like to see progress from industry. It's also an area where I'd like to have a dialogue around how high that bar should be set. But I'm quite clear that that bar is not set as low as it is being set by some firms right now.
Any other comments by two of you?
I can go ahead, Bojana, just to add also and to touch upon what you and Stephen were saying before about transparency. I think it's interesting to see that the DPB opinion touches on the concept of transparency in three different points. One is transparency as a principle. As you may know, this is not one of the main topics of the opinion, but the opinion highlights the importance of transparency in the context of compliance with data protection and AI models. It then touches on transparency with regard to reasonable expectations, as we were mentioning before, and it look at transparency as one indicator, so one element to look at, but it also highlights that simply updating a privacy notice does not help, should not help companies to tick the box of transparency, but still consider the role of transparency when meeting data subject reasonable expectations. And then the third point relates to mitigating measures that are additional safeguards, as the opinion says. So we can call them GDPR plus measures that can help companies to rely on legitimate interest if, let's say, they are not willing in the balancing test exercise. And this relates more to your last question, what is expected from companies. As I mentioned, this is not the role of the EDPB, but from the general observations that are provided in the opinion and the mitigating measures that are included there in the context of transparency, and also that comes from some of the views we received during the stakeholder events. I think we are a bit aligned with what the ICO were saying with regard to more can be done. For example, the use of FAQ, just-in-time notice, also graphics are mentioned in the opinion, but also, you know, depending on the complexity of what companies are doing with data, doing the extra mile, making the extra effort, and consider whether on top of the information that are required under the GDPR, I'm thinking of Article 13 and 14, some further elements about what you're doing with data could actually help individual. And this is really, I would say, the core of additional measures, mitigating measures for the DPB. Things that go farther than GDPR obligations, but that can help then controllers relying on legitimate interest. And on mitigating measure, just one last point, as Félicien was saying, of course, the discussions at the DPB were very lively, as you can imagine, and the work of authorities such as the CNIL that was quite advanced during the opinion helped a lot in the discussion and in feeding the discussion and reaching this conclusion. So I would like to thank them as well.
Okay.
Maybe just to jump in.
Please.
Thank you for this Diletta. Just to say that indeed we have with transparency is really paramount, and just wanted to add that there much more can be done. I agree with Stephen in particular regarding web scraping techniques when they are applied, and actually individuals that have actually no ideas what is collected or not. I mean, and it is still a very opaque thing, as some companies do not display at all what they are collected. And on our AI how-to sheet, so I completely agree with what the colleague said. We also proposed something that I don't know if it will make the cut or not, was to actually that the CNIL could have a register on which, on a voluntary basis, companies that would use some web scraping techniques would subscribe, or at least give their name and provide the link where they with the information on the what they on what kind of a website they scrapped, so on and so forth, and so people could actually have a place where they could browse and find whether or not they are concerned by these technologies. So as I said, I think this is very interesting techniques. I'm not sure it is something that should be done on a voluntary basis or hosted by a TPA such as the CNIL, but I think really it's more like I open a box here and a question no one has the answer, but for instance, it could make some sense that at the European level at least, some, I don't know, European agency actually host this initiative and help with the take into account these transparency requirements that are, on one hand, as I said earlier, obviously for data protection, but also slightly differently, but also for the exercise of other rights, such as for copyright issues and all these questions dealt with in the AI Act.
No, thank you very much. And in fact, I mean, we we think there is, the EU AI Act is going to probably help a little bit, because there is this requirement to provide AI literacy that is actually coming into force very soon. And we are kind of wondering whether this is a chance for organizations to not just upskill their own workforce, but generally provide more literacy on the use of AI, whether it is coming from client-facing, customer-facing, supplier-facing. I mean, so I think it's going to be a very dynamic area. And I'm going to ask also our private sector panelists about particular transparency. I do have a question that has come from the chat, which I was planning to ask all of you. And that is really the legal basis for processing sensitive personal data, which of course I know is a bit of a difficult one. Dare I say we might even have a legal lacuna here, or gap in regulation, in that there doesn't seem to be sufficient legal basis for using sensitive data for two things. One, for bias detection, non-discrimination, fairness, right, robustness of the model, which is necessary, we are told, by data scientists and necessary to retain. But also, secondly, if a organization wants to provide actually an AI application that is based on sensitive data, you know, providing better sight or hearing, or, you know, health related. I mean, the very purpose is to actually provide this data, train the application with sensitive data and to use sensitive data. There doesn't seem to be legal basis. You know, how are we going to, I know CNIL tried to address that. And so this is a question also we got from chat. Can you tell us what is the best approach here? Do we need to change in law potentially?
Should I start? I can try.
Yes,
It won't be a definitive answer, but and because it's a complicated question, I think there's many sub-questions and division of what are we talking about. But so first of all, indeed, in the how-to sheets, we recognize the fact that it is possible that if you use some web scraping techniques, you will incidentally collect some sensitive data. Could happen. So for this, what is said in the guidance is to say that you should, by design, exclude all domains and website that or parts of the web pages that are most likely to contain such data, to by design exclude the collection if that's not what is looked after. And we also acknowledge the fact that still you could find you could have some sensitive data collected, and afterwards, as soon as you identify them in the data sets, you should erase them. But then it is we also if you want to deal with specifically with sensitive data, as you said, for some potentially of course a legitimate purpose, then you will have to rely on obviously on a legal basis, consent or some other that might do the job. So from what I understand from your question is that what you say is that some people would like to actually use some web scraping technologies to collect sensitive data, and might not have the potentially relying on legitimate interest. That's what you said. So for this, we still are working. It is obviously an important topic, but thus far, we believe it's still complicated issue. Also, I wanted to add the fact that the AI Act introduces the possibility to collect sensitive data to make sure, in particular, that the data sets are not, in some circumstances, are not containing any bias or could lead to some discrimination. So that's also a very interesting possibility offered by this new
but for high risk, only for high risk systems.
Only for high risk, indeed. Yes.
Stephen, do you want to? Sorry, yeah.
Certainly. So I just wanted to really build on what Félicien was saying there in terms of, I suppose, thinking about this in different ways. So, you know, looking at where there is unintended collection of special category data, getting the assurances that organizations have done as much as is within their power to remove such data and to avoid its collection in the first place would be something that we should expect in any scenario where data is being collected. That's not something which is necessarily novel to this area. Of course, the nature and the volume of special category data that could be collected still, when all such mitigating measures are taken into account, would mean that organizations still need to think about whether they're getting to a situation where they will need an Article 9 condition in order to undertake even the minimum processing that is coming into play there. Moving forward, though, of course, there are two other kind of categories here. We've mentioned uses like bias mitigation, for example. The ICO has put out guidance around AI and fairness that treats questions of bias mitigation already. I won't repeat that guidance here, but I really recommend to people to look at that and look at our thinking around how that can be done. But then there's this kind of third category, which is intentional, actually, for the purposes of training for that. Let's imagine, for example, a medical transcription app that is intended to be used for in health-based circumstances where you want it to be trained on health-based text relating to individuals. I think there is a conversation that we need to start to spark there around, actually, in those sorts of circumstances, how would an organization go about doing that? How do we make sure that innovation reaches that part of the market? Are there downsides to some of the current framework?
Diletta, do you want to sort of answer this as well? And by the way, there's also a question to you from the chat. Why didn't EDPB arguably take into account the point of view of Hamburg DPA on whether LLM contains personal data or not? But
thanks a lot.
Yeah, if you can cover the sensitive data point, please.
Yeah, with regard to special categories of data, if you have read the opinion, there's a list of things that the opinion doesn't cover. Of course, it was decided to include them there because all the authorities, the EDPB, recognize the importance of those issues and the need to provide clarity on that. But I was mentioning before, the scope of the opinion is really provided by the questions of the Irish essay and the question related to legitimate interest. So it wasn't part of what we were supposed to cover with the opinion. Of course, this is an important topic that might, for instance, be covered in future guidelines. The opinion still includes some reference to the Bundeskartellamt judgment from the Court of Justice, and this idea that indeed when data are collected en bloc, then they should be considered as sensitive. There is no more specification there, but for instance, in the task force GPT report, that of course was related specifically to the operation of ChatGPT, but I think it can provide useful elements in general. There is reference to, for instance, the use of the exception of Article 9.2e and the fact that when data are manifestly made public by the data subject, that this aspect should be interpreted in a restrictive way. There is also reference to some of the measures Stephen was mentioning, filtering out sensitive data both when collecting and when after collection, so deleting this type of data. We didn't go into details in the opinion, but hopefully more guidelines will be provided in the future. With regard to the questions that we received in the chat, I think Félicien also touched upon it when he was speaking before. As you know, an opinion represents the views of all the authorities. So, of course, some of the authorities took specific position before the opinion was adopted. Some others were in a different moment of their work, like the CNIL, for example. So, waited also to see what was the result of the opinion. And there were very intense discussion in our subgroups and also at plenary level on all of the various questions, including anonymity of AI models, and also based on how the questions of the Irish essay was phrased, which was, can in all cases a model be considered anonymous? The answer of the EDPB was, no, it cannot, especially when personal data are used to train the model. So even I would say the start of the conversation for the DPB was a bit different from what the Hamburg DPA paper was starting from. And in any case, the opinion, I would say, build consensus by design. So consensus is, of course, the output of discussions and a common approach from various authorities.
And I think the opinion talks a lot about, you know, scenario A, scenario B. It gives some leeway to actually apply this to the context. I think this is really important. It really is all context-based. Nobody can say, in your particular case, you know, it's always going to be good legitimate interest. What you're creating is parameters and conditions so that companies actually have to be accountable as they're applying those conditions. I mean, we're coming to the end of this portion. And in fact, we've taken a little bit over, but it's incredibly important and interesting. I know there's some more questions about purpose limitation. Maybe I would just take liberty to say that what I have read in all of the regulatory work is that, in fact, AI training is a purpose in itself. And it seems that everybody agrees on that. And if that's the case, then we don't have a problem of purpose limitation. So it's a different, that there really are different, all of you talk about different stages of the AI development and deployment, from the collection to training to fine-tuning to deploy, and each of these is a purpose in its own. So, you know, that's the way to look at it, and then we can marry the two. I think there was a lot of great discussion in EDPB on risks and benefits. It was really great to see that. We always at CIPL believe it's important to look at the purpose of processing and purpose of use of AI through benefits as well as risks. And then again, likelihood, severity, really great. And then, of course, DPIAs, I think even CNIL as well. We know Stephen has been saying all the time, we need to do better. So I think we all have heard that we do have to create better evidence of privacy impact assessment, data protection impact assessment when it comes to AI. I will have to now move us on to the private sector conversation because they're only given now 15 or 20 minutes. But I have taken some questions through this chat. I mean, lots of work still to be done, but I think lots of answered questions, and we just have to take these answers as they come, as opposed to keep questioning them all the time. If I may say this to all of you listening. So be happy with what you have, grab it and apply it in the way that, you know, you can evidence that you've done that accountability. Now, can we move, please, to our private sector leaders and practitioners? With us, we've got, again, Cecilia Alvarez from Meta, who is a policy director of privacy for EMEA. Rashida Richardson, she's senior counsel for privacy, data protection, and AI at Mastercard. And Antonio Muñoz Marcos, who is the director data protection at the Global DPO office of Telefónica. So we said we were going to have 30 minutes. I think we're going to have to squeeze your conversation, and I apologize, but this was hopefully giving you lots of food for thought. But maybe why don't I start with very quickly asking all three of you to give us some indication of some some of the largest and most typical use cases of Gen AI in your organizations, all in different sectors. So Cecilia, should we start with you?
Thank you, and thank you for creating this event. It has been very insightful also to hear from the regulators before. So moving to the point that you have been asking us to address, as someone has been saying before, AI is actually fundamental and has been used by the companies for many years, and definitely this is not an exception in the Meta company. From the feed ranking, from community discovery, personalized ads, content moderation, all of these activities are powered by AI. But looking at the examples that you were looking for regarding GenAI, let me maybe pick some examples, such as Seamless M14. This is a first all-in-one multimodal, multilingual AI translation and transcription model. And this model can perform speech to text, speech to speech, text to speech, so all the combinations that we may have between these two words for up to 100 languages, depending on the task. And it was named one of the Time Magazine Best Inventions of 2023. If I may go to other kind of places in which, as you know, Llama, which is the name of our generative AI model, is open source and therefore used by a variety of organizations of the public and private sector for powering products. I can maybe just mention 2 or 3 as well regarding in the medical side, for example, that there is a company named Peace AI, which is a mental health companion app that features engaging conversations with multiple unique AI companions that learn in real-time realistic voice generation and provide goal tracking support, guided meditation, and much more. Other that is related to biomedical brain providers for biopharmaceutical companies. Another one with respect to leverage locally trained LLMs to create AI avatars that enable multilingual communications, personalized support, and dynamic engagement. I can go on, and I'm sure that other of the panelists would love also to share some other examples of what generative AI provides. Thank you.
Cecilia, I always love the examples of use of AI, in fact, to ensure compliance with safety and children's rights and all of that as well, which I think for social media companies is huge these days. Rashida, what about financial services organization like Mastercard?
Yeah, so I'll start with also saying thank you for having us here. Mastercard's exploring a variety of different ways to leverage Gen AI. Some are focused more internally on figuring out ways to develop more efficiencies to our internal procedures, and others are more customer-facing solutions. Rather than list off many, I'll just focus on one example that's been exciting here. A recent tool that we've developed is a digital assistant to help simplify customer onboarding. It's an LLM that employs RAG to retrieve the most accurate and pertinent information for customers throughout the onboarding process. And the goal is to help incorporate subject matter expert feedback throughout the process to ensure that the agent is both responsive and providing up-to-date and incisive information. And this is just an example of something that can help our customers get to market quicker, but also it leverages many existing tools to increase efficiencies across the board.
Great. And again, I've seen some of the interesting stuff in financial services with cybersecurity and fraud prevention. Again, huge use of AI. Antonio, what about telcos?
Yeah, thank you, Jana. We are using Gen AI system for example, customer service, call center support, commercial arguments for customers, preparation of technical offers, and even in some cases of HR, identifying skills based on curricula from employees, training or providing or recommending some specific training, or recommending some vacant position, for example. And we are also participating and fostering and providing some commercial offers in B2B segments for B2B customers when they want to use or integrate different products. And we also have a specific line for startups and small companies that want to launch some innovative ideas based in innovation, innovative ecosystem. So we are working with them, supporting them in as a downstream Gen AI provider based on the providers of Gen AI models. And one specific issue that I like a lot is such related with providing support for compliance and privacy. For example, we have a specific automation tool in order to take the purpose of a processing, take the the type of data that we want to use and the customer classification, and decide which will be the legal basis, if it's allow or forbidden depending on the access. So if you need some skills in order to do that, because you need to know SQL, you need to use some specific front end. But if we can use generative AI in order to ask specifically in plain text what you want to use with our customer database in order to look or to look for specific insights, is something that we are implementing right now, specifically for some queries or some information that is aggregated. We are not going, or we are not working specifically now individual basis, but providing support for some queries based on aggregated information. And we are also using a GenAI for DPIA's identification. For it's really hard for a big company to identify any say international transfer sub-processing in a DPIA. So having a tool in order to identify that, including in our registry of activities, and follow this issue, is something that is helping a lot at this moment.
I mean, and that's really great to hear, such a diversity of use cases, and including some for actually enabling compliance. And I think this is wherever I go, I keep hearing, there's a huge amounts of R&D going into now, ability to use data, corporate data, company data, third-party data, and of course, put that on top of the LLMs, which are commercially available. Yeah. In fact, today I am visiting Accenture in Munich and their innovation labs, and they were showing me some of their industry, particularly automotive industry applications of AI, but they also showed me the Gen AI built responsible AI platform, where in fact they can do internally to themselves and of course externally to the clients, to enable them to develop responsible AI with chatbots asking questions and leading through the process, which is phenomenal. So it's really good to hear that. Now, we have heard from the regulators, and of course you have seen the guidance, the opinions that have come in the last year. There still are concerns and unanswered questions on how data protection rules apply to Gen AI. So I would love to hear from you. First of all, what are some of the practical steps that you are doing to, if you like, address the compliance when it comes to legal basis, when it comes to transparency? We heard big area where we have to do better, doing even proper DPIAs, individual rights as well, sensitive data. So I'd love to hear some of the examples and how you are approaching this. Who would like to kick us off?
Yes, automating efforts in privacy is something that is needed, because in the end we are short teams, and we need to have tools in order to do this kind of thing. So in our case, we are working with a specific tool that we have to create in order to register and to link any kind of use of AI with other privacy or even intellectual property issues, security issues. So we are working and we are using a workflow in order to identify the different issues or different risks in order to have everything documented in order to take decisions properly. So and for this, we are leveraging in our privacy governance model and privacy tools that help a lot in order to decide if the things can be done in this way or in another, based on different legal basis or transparency requirements, or even more. One of the concerns that we could have in big organizations with Gen AI is that that this has democratized access to any kind of processing, in the sense of any employee using Gen AI model or license could convert our company in a deployer. So we need to have from a compliance perspective, has a good control over who is acquiring licenses from Gen AI providers for which purposes, because it's a very different approach than before with privacy, in the sense that with privacy you need a big machine with a lot of computer power, so it's more passive, more easy to identify that. But with Gen AI, it's very easy for somebody with a credit card number to license or to acquire a license of a Gen AI system without a big control over the rest from the rest of the company. So this is one of our main concern, how to control this kind of things. So I mean, this is a big, huge issue.
Thank you. Rashida, what about you? What are some of the responses to some of these data protection compliance challenges?
Up top, we have the Mastercard data and tech responsibility principles, which are undergirded by many different data protection principles like transparency, privacy, security, and that drives how we deal with data as a company and how we deal with technology development, including Gen AI, but we've also developed a dedicated process for generative AI use cases. So that's more of a do and don'ts policy for employees internally, but then it also goes through a cross-functional Gen AI committee review. And the reason I start with those is because I think it's important to understand that there is AI compliance where we're trying to comply with explicit rules and regulations in place. And then there's also aspects of responsible AI governance, which is more best practices and other policies and procedures that can be related to compliance, but can also be distinct. And so we try to have a reflexive policy overall that's ensuring that for the compliance piece, we have sort of policies, procedures, and mechanisms in place to comply, but also that there's some flexibility there where the law is a little gray. And so like there's areas like bias mitigation and identification where the actual rules of the road are not that clear and research is fairly nascent, or we're still trying to gather consensus. And I think that's where having a reflexive policy where we're both trying to lean into best practices and also comply with the sort of bright line rules is necessary.
Cecilia, but what about Meta? Because I mean, yours were some of these test cases, I think, that were challenging the use of first-party, third-party data, you know, legal basis, etc. So,
well, I will not necessarily go long with respect to the frustration that we do what the others are doing exactly the same, and we were delayed, no matter why, for something that then the opinion confirmed that actually we're doing in alignment with the final opinion. But let's focus on the examples. There is, I think, the starting point is with respect to the privacy review, which is a very specific process that exists at Meta regarding any product that is launched. And of course, among the privacy review elements are also those that encompass AI, because this is definitely not something that is first new. It has always been like this, but definitely we are incorporating also elements that are coming from the regulatory guidance. There are safety and privacy measures that are also incorporated, and thinking in particular with respect to the models. We distinguish the kind of measures that are incorporated during the training phase as opposed to those that are incorporated in the output phase, because not everything actually can work in the same way in the different phases of development of the model. I may just mention some because we are now short of time regarding in the training phases regarding the removal of structured identifiers from the training data set, and therefore there is no link to user identifiers for those data that are coming from the public internal sources. They are selecting also data sources. For example, those that are identified as robot.txt are definitely respected in the way they are not incorporated in the models. The duplication elements with respect to the training data set. I know go a bit fast because there are so many, just to give a flavor of the kind of things that are relevant in the process. In the output phase, we can maybe highlight the output filters in order to remove content that the data subject considers objectionable. And this is linked, let's say, to the exercise of, as the keys may be objections at the relevant time. And this is linked to something that I believe has been part of a main focus in the regulators panel regarding the transparency measures that goes beyond what the privacy policy can actually be saying. In particular, and we have in a privacy center that is available publicly for all the users, and they can have in particular access to an AI privacy center, particularly article in which it is explained how generative AI model works and clarifying the role that personal data may play there. And it links also to additional resources, in particular the data subjects rights form, and showcasing also how there is a commitment with respect to mitigating privacy risks. There is also a consumer-friendly guide on privacy mitigations during AI model development and deployment, because as I mentioned before, when I think or we speak about the generative AI models that are open source, this is accompanied, let's say, by a guide also for the developers. I may also mention the teen guide, which introduces generative AI to youth and making it accessible and informative, and it also provides links to other resources, in particular, including also the data subject rights page and ensuring that there is a transparency for all ages. So there are more things, but I think that I tried to give examples of very different nature of measures that I think could provide a good landscape of kind of things that companies we are currently developing.
And this is really consistent to what we have been seeing also through our sort of evidence-based research. But of course, it is such a growing field, and the things that you've enumerated is already a step forward to where we were like 6 months ago as well. And it shows you what is possible. And to Rashida's point, some of this is driven by compliance, but some of this is driven also by best practices, right? Because this is what responsible AI looks like. I'd like you three please address in particular quickly the use of privacy enhancing technologies in AI. I mean, this is something, again, CIPL has done lots of work, and now we are just about to publish a deeper dive vertical into use of pets in AI with lots of case studies. But there seems to be some promise there, but of course not a panacea in terms of synthetic data, differential privacy, etc. So any comments from you three, please, on the usefulness, or what else can regulators do to promote pets?
I'll go in that we are exploring pets as a mechanism for advancing data privacy and data protection principles. 2 examples are one way we've tried to leverage it is creating synthetic data to ensure anonymity and aggregate data sets for training, pre-processing, and fine-tuning of models. And another way we've also tried to leverage synthetic data is to use it for testing and monitoring for bias and discrimination. But I think, like you've already said, this is an area of open research. So I think we've wanted to explore this interest, but we're also trying to be prudent and not moving too fast because there's areas where there's still a lot of unknowns. And that's where we've tried to leverage partnerships with academic institutions or even our participation in collaborative spaces like safety institutes to see where we can get clearer research on standards or best practices to inform what we're doing internally.
Others?
Yeah, we have been working in pets for years. I mean, this is not new, mainly in big data and in particular operators where we process location data to create aggregated insights. I think specifically during the pandemic. So using different anonymization techniques is something that is one of our main efforts. Using safe environments pseudonymized data in order to aggregate it, extrapolate it, and so on. And also we are exploring the possibility of using AI to solve the trade-off, or to help in solving the trade-off between the level of aggregation and the elimination of singularities with the desirable utility measure of the data set. So I think that we are exploring these kind of capabilities of AI in order to help for anonymization.
Great. Cecilia?
Yes, I think that I can refer, among others, with respect to the programs that we have in the Data for Good, that actually has been facilitated thanks to different kind of PET techniques with respect to users, such as maps to expand polio vaccination in certain countries, or to leverage to expand water and sanitization programs in places that are very difficult to get these kind of things. Just a flavor, because they are many programs in which this kind of PETs have actually been facilitating that we can put either data sets on a certain manner, or that we can have AI-driven tools available in order to produce this kind of results. But the part of the safeguards that I mentioned before regarding something that goes beyond, let's say, what is not necessarily listed, let's say, in the GDPR per se, are actually kind of PETs or anonymization measures. When we think about the deduplication, or when we think about removal structural identifiers, there are different flavors, let's say, of getting to this kind of result that are adapted, let's say, to the different phases and the kind of utility, which is something that Antonio was mentioning, and is always part of the discussion in PETs, that depending on the kind of technique that you use and the context, you are going to sacrifice always part of the utility. And sometimes it is worth it and it doesn't matter for the purpose that you have. And in other cases, it does matter, and therefore you need to do this in a different manner. So what I'm saying is that PET is not necessarily always the most appropriate thing to do in all cases, that you need to address the kind of purpose that you have. And when we think about GenAI training, the kind of measures that I mentioned are those that have been tested to be maintaining this utility, because we definitely need these models to understand the real world. And the real world is the realities in which human beings are expressing themselves and are saying things. And it's not necessarily that we need to know what Boyana, Cecilia, Antonio, Rashida may look at or think about something, but what the human beings of certain characteristics are thinking about something, and how we represent the world in which we are living. So we need also to be always cognizant with respect to this aspect. And if I may end, let's say, the PETs chapter, I will zoom more. It's not only generative AI, is with respect to how we encourage and facilitate and promote these kind of techniques at the right level. And for this, we need to act on, I think, several kind of issues. One, the anonymization concept. And there are now guidelines that have been actually been published in draft, which is very important. And there are two aspects in this anonymization. One, the legal basis, that I understand that the EDPB is proposing a way that probably could be workable in this connection. The other one is the threshold that you take in order to consider that data is anonymous or not. In the case of these guidance, I think that there is a lot of work to be done in this respect. And there is another problem that is a consubstantial problem that we have in Europe with respect to how we address joint controllership. And this is a problem also for the PETs, because if everybody, so the thing is that we know that the GDPR attributes at the end joint and several liability, no matter what are the arrangements among the controllers. And this is a big problem when the thing that you are making from a conceptual viewpoint doesn't correspond to the reality and to your scope of control. And this is an issue that is not new, but it also has a harm in how we facilitate or not that PETs are developed.
Right. And this is why, I mean, we had a comment in the chat, the importance of actually having this dialogue with regulators all the time and explaining what the reality looks like and how actually the technologies are developed and used. And we need also data to develop PETs. I mean, we are coming to an end, but I do have to ask this question, please, very briefly. Cecilia, I'll start from you. And I hope people can stay for a few more minutes. But I mean, you've heard the discussions by the regulators, and sort of direction of travel on the implementation of the principles. I think there's still clearly some challenges and if you like expectations very clearly set out by these regulators on, doing better in terms of transparency, setting the reasonable expectation of individuals, DPIAs, risks and benefits, of course, individual rights. I mean, what is your reaction to the regulatory guidance and opinions that we have seen, and also to some of the policy of governments? We've seen the UK government policy, very pro-AI, pro-innovation. So, what are there areas where we need more guidance, more conversations? Are there areas where it's difficult to comply or fulfill those expectations? Cecilia. It's a difficult question, this.
It is
but
a
I'm going to
difficult
pose
question. But I will maybe just say that we should concentrate in finding solutions instead of being the champions of finding problems.
Okay. Point taken. I like that. Rashida, what's your view on the guidance and the usefulness of what has come out? And those.
Yeah, I think we need more guidance. And to answer the second half of your question about where that sort of energy can focus is, I think one area that I referenced earlier is lawful processing of special category data for bias testing and mitigation, because that's an area where in the AI Act there's references, but it's still very vague. So we need further guidance. And like I mentioned earlier, it's also an area that's fairly nascent in research and development. So essentially everyone has to make up their own rules of the road. And I do think it's also an area where we see there's interest in different jurisdictions, but there hasn't been a real effort towards harmonization. So it just feels like a big vacuum of area that is ripe for more guidance and work with regulators.
Great, thank you for that. Antonio, the same question to you.
Yeah, I think that the AI literacy is one of the big issues. When we talk about reasonable expectations, I think that it's a cultural-driven issue that will change over time, and for that we need we all of that have a responsibility in order to provide enough information to the public. What is our responsible AI, and how we are working with that. Also, as a downstream providers, and based on the EDPB guidelines, but this is something that I think that need more details, is about how we as downstream providers or downstream deployers will be affected by the privacy issues regarding large models. I think that in the future, and given that the models will be some kind of technical infrastructure for everything, we will have different flavors with different models, with different training data for different purposes. So even where there are general models, we'll have to fit different. We will need some kind of operational controls when using these kind of models, and working these kind of things will be very, very beneficial for the whole ecosystem of deployers.
Okay, well, I think that's quite a big challenge. That's quite a big challenge, actually, at the end. And it seems to me it brings us back to what the regulators have said, the complex ecosystem with a very complex products and complex chain of liability and roles, and how that also works, particularly with Gen AI, which is general purpose. But so when you're developing, you do not know the purpose, but when you're using it, you do know the purpose. I am being told we have to stop now. I mean, there's some interesting questions, and maybe why don't I ask this last one, just to be fair to our audience. How do you at Telefónica, but maybe all three of you, deal with AI fascination against the AI fear? So particularly when it comes to privacy and security. So how do you do that? And I mean, you all work for companies where I think there's a lot of AI fascination.
I think that we need to make some kind of trade-off. I think that I will not. We cannot live in a world where everything new is something that is expected to some bad results. I think that we need to work in a very mature mind with knowing that we are in a fascinating moment with a lot of challenges, and we need to work responsible. We have been providing different guidelines about the use of AI for the public in order to create this provide this balance in a smarter way. I mean, we cannot be negative. We cannot be a fan for everything and very, very positive. We need to be in the middle of that. And this is our responsibility of, in our case, as IA compliance. And that the organization knows that, should know that we are not only, we are not saying yes to everything, but not no to everything, in the middle of and having good answers with good reasons.
Cecilia?
I think Antonio has described our work. We live with these two poles in tension, which I think the only way to survive is to continue being curious in order to better understand what is your surrounding, and also to not forget the reasons why we have data protection laws and why we also have a European data strategy in the case of the European Union, or an EU AI, UK Opportunities AI plan as well. So it's just that we need to take into account the equities and not just to isolate ourselves in a single lens. And sometimes we go to a single lens because we're specialists in data protection, but it is something that is broader, and this is the beauty and the difficulty of it.
And may I sort of provoke you here? I think you recently made some changes last year in the setup within Meta, where your Chief Privacy Officer for Products is now overseeing a number of data regulatory areas to provide that holistic point of view. Is that the good way forward? And are you seeing benefits of that? Of course, it's a difficult process, but it's the right one. And we were delighted to see that.
It's a very difficult process, but probably is the best one that we have found in order to address the interplays among the very different regulations, because otherwise we have teams that are speaking about their DSA thing and the DMA thing, and all of this needs to work together with all the incoherences that the process of how the legislation is produced has. So I think it's the best way that we have found, but it's definitely a difficult one.
It's a journey, but it's a good one. Rashida, you've got the last word.
I think what we're doing kind of echoes what we've heard from the other panelists, in that we're trying to provide more opportunities for learning, both understanding the technology and its possibilities, but also I think understanding the legal and regulatory landscape. So it's not seen as fear, but an understanding of risk that needs to be mitigated that can ultimately help with enabling more innovation. And I think we're just trying to find different approaches to providing those learning opportunities. Some of it is more traditional training that is required by law, but also some of it is more I guess I would say interpersonal, of like we have these learning circles where you can just talk to subject matter experts who are specializing in different aspects of our AI governance and review process, to both understand the different career trajectories, but also the different perspectives.
Well, with that, I'm just going to give you what I think is a CIPL's point of view on this. We do, in some ways, yes, it's a trade-off, yes, it's a balance, but actually we need both responsible handling of data, responsible development of technologies, and trust and innovation, right? So we think actually that responsibility and accountability in AI development, deployment, training, and use of technology actually is good for business. It's not something that companies should be doing just because the law says so, but actually it delivers better business outcomes and ultimately better competitive place in the market. So, for us, it's really the two are going hand in hand. So maybe that's the answer to how to deal with the fascination and fear at the same time, and how not to be the department of know, both on regulator side, but also us as privacy and data practitioners. With that, I have to stop. We have taken a little bit over time, but I know this was an incredibly fascinating discussion. All I can say is big thank you to everybody for being very open, very chatty, very considerate, and ready to engage. And we do thank also our regulators for being with us. We'll do more of this and we'll do deep dives. And I promise the CIPL will be working on best practices for each of the challenges you have put to us, and we'll collect those and come back with the homework hopefully well done. Thank you very much again.